Part 3. Monopolies and competition law. Monopoly exists where there is only one supplier of a product or service within a market. This means that the consumer does not have a choice of supplier if they require this type of product or service. The single supplier is then in a position where they are able to charge higher prices, and they do not need to continue to improve the product or the service that they offer. For example, transport for London. Monopolies can occur as follows. 1. Legally enforced monopolies supported by the government. 2. A monopoly due to ownership of a patent or copyright. For example, the introduction of a new drug. And 3. Natural monopolies. For example, where the construction of a network or a pipeline is so expensive that there is only one company that can actually afford to act as a provider. And 4. Cartels, which are agreements on the fixing of pricing and volumes and which are illegal within the United Kingdom. There is the Fair Trading Act 1973 in the UK, which defines a monopoly as being a 25% or more market share within a complex market. So here it does not have to be 100%, it has to be 25% or more. If an organisation has the opportunity to acquire another organisation, but the combined market shares of the products that they make in a particular market would then exceed 25%, the Office of Fair Trading would investigate this to decide whether it would or whether it would not be in the public's interest for this merger, this acquisition to take place. If it was decided that it would be in the public's interest, then the two companies would be allowed to go ahead with their plans to join together. But if it was decided that it would not be in the public's interest, then certain provisos would need to be agreed before this linking together would be allowed. For example, it might be decided that one of the two brands in a particular market would have to be sold to reduce their combined market dominance. A previous government in the UK, the Labour government in fact, would not allow Lloyds Bank to purchase Nationwide, as combined they would be too dominant in the mortgage market in the UK. Instead, Santander, a Spanish bank, was allowed to acquire Nationwide, as their market share in the UK at that time was quite small. There are other laws in the UK which also affect this area of business, such as the Competition Act 1998, the Enterprise Act 2002. So companies in the UK must comply with UK competition law and with European Union competition law. Business activities which are prohibited include agreements which directly or indirectly fix the purchase price or the selling price, agreements which limit or control production, markets, technical development or investment, agreements which share markets or sources of supply, agreements which apply dissimilar conditions to similar transactions, which would then place other trading parties at a disadvantage. If an organisation does contravene the law, then it may face a fine of up to 10% of its total group global turnover, which can run into millions of pounds, of course, if it's a large multinational. The provision in agreements being made null and void and unenforceable, and customers and competitors may take them to court in a bid to be awarded damages. Indeed, individuals within the company may be disqualified from being allowed to continue as a company director, and it may lead to a court case due to criminal activity, and the person or persons concerned may be imprisoned.